Love you, Linda. Love you.
The courthouse the other day in the hallway, you're singing "Oh Happy Day."
One word prayer. Justice, where are you?
All right. He's so late, he's just barely sticking his microphone on, as they say. And the wire shows, who cares? Hey, good morning, Justice Through TV. Michael Bryant here. We're not going to do much today because we're going to let the court do their thing. And today is jury instruction conference in the Karen Reed case. We weren't sure for a while if it was going to even be televised, but I heard Long Crime is in there. We see the fan. Can't understate, or can I overstate? I can't overstate the importance of the instructions that are going to be settled on today. And I don't mean just the rip them out of the book standard jury instructions. Badgic, I think it's in California, it was called Badgic. Something jury instruction something. So there are a lot of those that is very basic, but we know from the proposed instructions, that were released, at least a few of the Commonwealth requests are batshit crazy, including an instruction that Karen Reed intimidated witnesses. And if you find that jury, you could use that in these other charges. Oh, yeah, she wasn't charged with witness intimidation. Whoopsie. Anyway, would that come in the real world? No. Will it come in this world? Hey, could be, because we're not in the real world here with this case. So we're just gonna roll into that when it happens. I got to do a bunch of stuff to finalize some files that I've got to get done before I head out tomorrow morning for Dedham. Get there. I plan to get there at or about the time closing arguments begin. Obviously, I'm still ostracized from the courtroom because I'm not a journalist. Can't even get on the randomizer list. I don't know what you got to do. Maybe another 40 years in the business, so I'll get qualified. But anyway, I'm not bitter. So we'll talk with the folks outside, get some of our local flavor, talk to our usual suspects, and then just, take it all in. 31 days, 32 will be tomorrow in court for this trial. A very different trial than we saw in trial number one. A lot cleaner, a lot more streamlined, a lot more of the core principles the defense has been trying to push, which is no collision, no collision, no collision. And we certainly saw that with the final three defense witnesses. I think to the point that Mr. Brennan said, yes, Mr. He's like this, Mr. Welcher, don't come near the courthouse. Not even on the sidewalk. No, in fact, stay out of town. Yeah, where are you now? Stay there. So, Welcher not coming back. As entertaining as that might have been after we heard the testimony of Dr. Rentschler, who just eviscerated any of the massive number of tests. Oh, wait, he only did one test. Eviscerated that one test and told this jury how ridiculous the Blue Man Group experiment was. The paint test. When they started boiling it down to calling it the paint test, I knew they were doomed. That is not the scientific name you really want. We want to hear things like mass and velocity and impact and pounds of force. No, we had the paint test. So how the jury sees all of this, who knows? But we are going to find out soon enough. We've learned, and we believe this to be true. We'll find out perhaps a little bit later as the court wraps on the jury instruction conference. Going to be a question as to whether Judge Kenney allows each side an hour and 15, which she hinted she might, or the hour and a half that Mr. Jackson requested. Mr. Jackson, So, she obviously early on said an hour. There's been a request to extend that. I think he's smart enough to say, give me 90, Judge, because he knows the judge is going to say, no way, but I'll give you 75, an hour and 15. That's what I expect. So we think the order is going to be, closings, instructions. Here, jury, you got the case. So they could have it early afternoon tomorrow, probably for sure. And we're hearing they can deliberate until 7 p.m. Nothing screams, give me a Friday verdict so we can all get the hell out of here, like extending the jury deliberation time into and well past the court hours, into the evening. Friday evening, 7 o'clock. There's only one reason to do that. You, as the court official, want a verdict. That's it. What I would do, what would be more prudent, but that's not going to happen here, is you would give them the case, let them chew on it for a few hours, check in with them at 5-ish, and say, how's it going? Just in general, you think a couple more hours here tonight is going to matter, or should we just call it and we'll see you Monday? That would be the reasonable thing to do, which means it is absolutely not going to happen here. So they could grind away till 7, make zero progress, and then have to come back on Monday. And then, so what's the point of extending it to 7 o'clock? There is no point. So did a little teaser for tonight's show. I was wandering around with the dog. And I'll post that to our members only channel. We had a wild encounter. I am just north of the city. I am in Connecticut, and where we have like real trees and less concrete. Not that that's a bad thing to have concrete, but sometimes you got to get out. And so we're walking and found some very interesting local wildlife, which Domino was very interested in. So that just became kind of organically part of the promo for tonight, in which we're going to go over, among other things, we're going to look back at some of the opening statements from both sides. Not the whole thing, because that's an hour each, and that's a lot. But I'll try and pick and choose some stuff we can go over and talk about. And critically for the jury, what, if anything, was missed, left out, maybe overpromised, because jurors, they keep track of this stuff. And if they think, hey, I was told we're going to find out about Chloe. Well, we didn't find out much about Chloe at all, did we? So that'll be interesting. And then we'll, of course, have a chance to see what, to the degree that they share, the court shares with us, the jury instructions that have made it through the mix. Which ones? I'm guessing there are 4 or 5 that are just going to be hard fought, and the rest are not. So we'll have all that to deal with. So we'll pick that up at 6 o'clock tonight. Linda Kenney Baden, you'll be happy to know, has arrived safely at her secret compound. And we'll be back on the air at 6 o'clock tonight. She even threatened to join later today if this thing is still underway after a couple of hours. So I'm going to be off running around. I'm going to get a tent for tomorrow, just a little pop-up. I'm going to have a regular mobile studio, different than the past where I've been. Here's me in the past in the sun. I can't even see the screen. I can't read anything. It's a pleasure. So I'm going to get a little pop-up that will help kind of make that more comfortable, more practical. But you know what? Tomorrow, not only is it Friday the 13th, no, don't freak out. No tricksadecaphobiasts here. But it's going to be like 85, 87 degrees. We've had rain, and temps in the low 70s at best, popping up to 80-ish today. This is primarily in the Northeast, give or take a couple of degrees. 87 tomorrow. It is going to be sweltering on Friday the 13th when the jury gets the Karen Reed case. I mean, should you buy a lottery ticket, or should you just hide in your basement, because who knows what's going to happen on this catastrophic day? Could be catastrophic for one side or the other. So anyway, wait, it's happening. So I'm going to leave you guys to.
Good morning, Your Honor. May I call the case? Please. For the record before the court is Commonwealth versus Karen Reed, 22 CR 117. The parties are present. The jury is not present. The matter is on for trial. If the parties could please identify themselves for the record. Good morning, Your Honor.
Good morning, Ms. McLaughlin. Good morning, Mr. Lally.
Good morning, like the old days.
Good morning, Mr. Brennan.
Good morning, Your Honor. Robert Alessi from Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Yannetti from Karen Reed.
Good morning, Mr. Yannetti, and good morning, Ms. Reed.
Look who's missing.
All right, so Mr. Yannetti and Mr. Alessi, you're standing in also for Mr. Jackson and Ms. Little?
We are.
Okay. All
They
right.
got things to work on.
So first thing we left off yesterday was whether KKKK for identification, the PowerPoint of Dr. Rentschler would be entered into evidence. It will not be based on the objection, so it is excluded from evidence. So
What?
it's marked still for
What?
identification, and your rights are saved on that. So we ready to go forward with the charge conference?
Yes, Your Honor. I guess I have a question first as to whether the court would like to entertain the argument on the motion for the party finding not to close all the evidence.
So no, we can do that now. So now that my ruling is on this, Evidence is closed. Evidence is closed as it was yesterday. So go ahead on your required finding argument. Sure.
Now all the evidence is in. Now the defense is officially resting.
And this is not lengthy, Judge, 5 or 10 minutes.
Take your time.
Thank you. We are renewing our motion for required finding of not guilty at the close of all the evidence, and in so doing, Your Honor, we're incorporating our oral argument in support of this motion that we made at the close of the Commonwealth case. At that juncture, Your Honor, the Commonwealth had produced no witnesses to testify that John O'Keefe's injuries were consistent with his having been hit by a motor vehicle, and if he was not hit by a motor vehicle, none of these 3 indictments may stand. The Commonwealth, we believe, at that time fell woefully short of proving their case. Now that the defense has put on a case, the Commonwealth's case has been further weakened, such that none of these charges can stand. Nearly every witness, Your Honor, we have called, we would submit, has destroyed the Commonwealth's theory of the case. Dr. Russell testified for the defense. She's a leading expert on dog bite wound pattern recognition in the country, and she testified about medical injury causation and provided the jury with her expert opinion that John O'Keefe's injuries were consistent with dog-inflicted wounds, both bites and scratches. I would remind the court at this juncture that there was a dog at the very residence where John O'Keefe was found, a dog which was a longtime member of the family, which the family gave away after John O'Keefe's death. A dog which mysteriously was absent from the home at 6:30 in the morning on January 29th, when Jennifer McCabe claimed that she burst into Brian Albert's bedroom where the dog always slept. A dog which was absent from the home when the Canton police entered the home later that morning. Importantly, Dr. Russell agreed with the Commonwealth's medical examiner, Dr. Bello, that John O'Keefe suffered no injuries that were consistent with having been in a motor vehicle collision. And again, if there's no collision, there's no case. Dr. Lopesada, one of the most experienced and accomplished forensic pathologists you could find anywhere, agreed with Dr. Russell that John O'Keefe's injuries were consistent with an animal attack. And she agreed with both Dr. Russell and the Commonwealth's expert, Dr. Bello, that John O'Keefe was not hit by a motor vehicle. So the question is, in what type of murder case would a judge ever allow a motion for required finding of not guilty? In a murder case where expert testimony on both sides is that the evidence is inconsistent completely with the Commonwealth's theory of the case, that's exactly what we have here. But it doesn't stop there. Both witnesses from ARCA drove a stake through the heart of the Commonwealth's case. Dr. Wolf concluded that the damage to Ms. Reed's Lexus was inconsistent with having come from a collision with John O'Keefe. Unlike Dr. Welcher, who created, we would submit, a meaningless experiment based on no scientific method, Dr. Welcher actually did the proper force analysis and concluded that Ms. Reed's Lexus was not damaged by the body or the arm of John O'Keefe. His testimony was unimpacted by cross-examination, and it's devastating to the Commonwealth's case. Dr. Rentschler further cemented that there was no collision between the Lexus and John O'Keefe. It is simply not possible that this 6,000-pound SUV hit John O'Keefe at 24 miles an hour and caused only superficial wounds to his right arm with no injuries to his legs or lower body. The SUV did not hit him. John O'Keefe was not hit by the SUV. The case is over. But on top of all that scientific evidence, Your Honor, there were 3 additional fact witnesses who testified for the defense who corroborated that the Commonwealth's theory of the case is false. Sergeant Nicholas Barros, a sworn police officer, testified that when he saw Ms. Reed's SUV that day, before it was towed to the Canton Police Sally Port, the taillight was merely cracked. When he was shown photos of what it looked like in the Sally Port after Michael Proctor had access to it, Sergeant Barros confirmed that it was absolutely different. Karina Kolakithis confirmed that there were no problems between Karen and John O'Keefe that night, even remarking on just how sweet he kissed her on the forehead shortly before they left the waterfall. But perhaps more importantly, that kiss happened right in front of Brian Higgins, the same Brian Higgins who had been flirting with Karen Reed that month, the same Brian Higgins whom Karen had ghosted for several days before January 28th, the same Brian Higgins who had texted Karen that very night, well, and received no response, the same Brian Higgins whom Karen had given her back to all night, the same Brian Higgins who had to be restrained at the end of the night by Chris Albert on video, the same Brian Alberts who is on video, hot, angry. I meant Higgins, yes. Yeah, the same Brian Higgins.
Oh, nice to correct you.
Who is on video, hot, angry, and gesturing to John O'Keefe to meet him outside shortly before they left the waterfall and shortly before John O'Keefe was killed. And finally, Brian Loughran, plowing Fairview Road at 2:45 in the morning, was attentive, watching everything in front of him, very familiar with the Alberts residence, and had every reason to protect the Albert family. You recall that he did protect the Albert family to a degree that night by choosing not to follow protocol and call the DPW or the police about the Ford Edge parked on the street outside their property during a snow emergency. Brian Loughran confirmed that John O'Keefe was not on the front lawn at the Albert residence at 2:45 a.m. That means that Karen did not hit him. There was no collision. All the experts agree on that, including the Commonwealth expert, and the only eyewitness that morning confirms it. Taking the evidence in the light most favorable to the Commonwealth at this juncture, with their evidence weakened by an airtight defense to these charges, these indictments cannot stand, and we urge this court to enter required findings of not guilty on all three indictments.
Thank you. You're all set. Yeah, you know it's a loser when Lolly's
Thank you, Your Honor.
covering
The
it.
Commonwealth requests that the defendant's motion for required finding not guilty at this juncture, as it was at the close of the Commonwealth's case, be denied. The state of the evidence is not dramatically changed since the Commonwealth rested its case in chief. Counsel makes reference to dog or canine. I would remind the court that there is absolutely no evidence, none, not even a scintilla of evidence of a dog. There is no evidence of an absence of a dog. You have Ms. McCabe testifying that she didn't see it in the morning, which does not equate to there being an absence of a dog there. The arguments from counsel of the Commonwealth would suggest grossly exaggerates the strength of the defense witnesses in their case. The bias and advocacy exhibited by those witnesses from that witness stand do not amount to credible witness testimony that undermine the Commonwealth's case in any way, shape, or form. A couple of specific examples when it came to Officer Barros, his testimony was also that the cruiser camera footage from 8:22 in the morning at the driveway at One Meadows Ave, he indicated the damage to the taillight was consistent with the damage that he observed in the driveway at the defendant's parents' home, which was then consistent from the video or the photographs within the Sally Port. It's also consistent with 5:07 a.m. at One Meadows Ave on the still frame shots from that ring camera video. Essentially, the Commonwealth would submit that the defense witnesses all conflict with each other. You have a couple witnesses testifying about dog or animal bites. Then you have the ARCA witnesses testifying about superficial abrasions. You have Dr. La Posada talking about the drop in body temperature, which conflicts with Mr. Loughran's testimony as far as his confusion, as far as the hours of when he sees or claims to have driven by there and not seen a body. This is the same witness who is, I would submit, very confused on times, and then also backed into a basketball hoop during the course of his plow duties on that particular early morning as well. And as the court could see from the cruiser camera video, drove by the scene countless times, essentially rubbernecking it as he's going past doing his duties. Your Honor, what the Commonwealth would submit is that his case was more than sufficiently strong at the close of the evidence in his case in chief. There's been nothing presented in the defendant's case to diminish, particularly to the standards in the light most favorable to the Commonwealth, and we request that the defendant's motion be denied.
So, Mr. Kenney, you know I have to view this in the light most favorable.
I do, Your Honor.
And viewing it that way, the Commonwealth has met its burden, so the motion's denied.
Thank you, Your Honor.
Okay. All right. So regarding the charge, So we'll start with the defendant's missing witness request. Who's arguing that motion?
We're not arguing that, Your Honor. And I apologize, but we made the decision last night to withdraw 2 of our requested instructions with shortened things today. I think it's.
Oh, okay, so everything on this is done, right? The defendant's motion to present a missing witness argument and request for instruction, you're withdrawing that?
With regard to the absent witness instruction, we're withdrawing that request.
Okay. And what else from your proposed instructions? You said there were 2. What's the second one?
The second one is that there's an entry on our request for lost or destroyed evidence where we're withdrawing that.
Okay, I had a question about that. All right, thank you.
There is a supplemental instruction that we're asking the court to give regarding the display of this sweatshirt.
Oh, that's right. I saw it in email. I don't have a hard copy of it.
That's Mr. Less's motion.
Your Honor, if it's helpful to Your Honor, I'll hand up my hard copy.
Okay, if you could do that, I'd like to go back through the rest of it and come back to that after I've read it, okay? Who's arguing for the rest of the defendant's proposed instructions?
I am, Your Honor.
Okay, so we're gonna go through them one at a time. Who's arguing for the Commonwealth? Okay, so I think you're sort of in agreement on the basis of the law, right?
Yes.
All right, so model homicide instructions, just as last time. So that takes a lot of time out of today.
Your Honor, the only thing I would draw the court's attention, the Commonwealth does have a request for, and I understand what the court's position might be on this, but as far as the instruction relating to murder charge, Commonwealth is only seeking instruction on murder charge.
All right, so we will deal with that. I'm going to go through the defendant's instructions are sort of the general instructions first, so it's probably easier to go through those, and then we'll have the argument on that. So presumption of innocence, I think my presumption of innocence is a little more robust than what you've requested, so I will probably, okay. And I will give some version. I know that there was a lot of attention paid and some appellate decisions on the each individual indictment. I'll give some further language on that. You've got an instruction proposed on page 4, reaching a verdict. Just, I will make it crystal clear, though. I think it was, and I was upheld on it. So I will make it crystal clear. Okay. So I'll give you that, Ms. Giannetti. This what is evidence. I probably won't give verbatim what you have. I'll take a look at it, but I will certainly cover all these topics. So Ms. Giannetti, you're telling me that your client wants me to give a defendant did not testify instruction?
Yes, please, Your Honor.
Again, if you want to take a look at what I gave last year, I think it's a little more robust than this.
I think we answered satisfied with the court's instructions on that, so we would be satisfied again with the court's language.
Okay. Humane practice, I will give you Baden. I'm going to take a look, size this up with what I gave last year. I gave Baden last year. I gave a Baden instruction. I don't think the Commonwealth objects, right?
We would object to the instruction.
Okay. Go ahead. Do you want to make an argument?
Just briefly, Your Honor, when it comes to the Baden, and I would incorporate, and I know there's no request for instruction for third-party culprit, but the Commonwealth would be making a similar request that counsel be prohibited from making a third-party culprit or Baden argument.
Or Baden? Or Baden?
I'm sorry?
You don't think the Commonwealth, the defense should be allowed to make a Baden to argue Baden?
So I would submit, Your Honor, that the entirety of any testimony or evidence related to either Baden or third-party culprit in this trial has come from questions from the defense, from actual evidence in the case, from testimony from witnesses to the stand, exhibits that have been put into evidence, or anything of the like. So in the instruction and arguments are based or predicated in the case law on evidence. And obviously, as you're well aware, there's a specific instruction that no matter how powerful they are, questions to counsel are not evidence. So what the Commonwealth would submit is that the court looks at what is actually in evidence in this case. There is no basis whatsoever for not only a vote or third-party vote for instruction, but specifically for even counsel to make that argument during the course of the closing. And I understand voting is a little bit more loose as far as the board certainly.
So I'm going to ask Ms. Giannetti to explain to me. All right, so I disagree with you on Bowden, but I'll take a closer look at it. Mr. Giannetti, what is the Bowden evidence that warrants an instruction?
I think it's multifaceted, Your Honor. The police did not secure the crime scene properly. They used inadequate material to pack the evidence. Chain of custody was contaminated and corrupted. There was evidence of bias. The lead investigator, failure to pursue the suspects, specifically telling his friends that the homeowner was sacrosanct because he's a Boston cop too. There was just a focus on Ms. Reed to the exclusion of everybody else. It was not an open-ended investigation. From day one, it was focused on one person and one person only. And just responding briefly to Mr. Lowry's comments about how being introduced affirmative evidence of the proper way to do an investigation. We tried, Your Honor, we made a motion and renewed it, asking for reconsideration of the court's ruling that Mike Easter could not testify about an investigation. So to say that we didn't introduce that evidence when we tried to do it.
I think what Mr. Lally was saying, that you asked questions but weren't given answers. And so I think that's what was said. I'm going to, Mr. Yannetti, I'm going to allow you to argue Bowden, and I am going to give an instruction. So third-party culprit's an entirely different animal here. I know. But tell me, are you going to argue it? Is the defense going to argue that Brian Higgins did this?
No, we're going to argue that the police failed to investigate whether Brian Higgins did it.
Okay, so just so that it's clear, that you all know, I believe, third-party culprit separately is a lot different than third-party culprit as it goes to Bowden. I ruled pre-trial that there could be no attempt at introducing third-party culprit evidence regarding Colin Albert. So that was separate. But I did say that I would give you the opportunity to try and develop testimony regarding Brian Higgins and Brian Albert as third-party culprits. That threshold that you need to make to do that, to argue them as three-party culprits, has not been made by the defense. So you cannot argue that either Brian Higgins or Brian Albert committed or had the motive and all of that. Not third-party culprit, pure third-party culprit. You understand that? It sounds like you're telling me you don't intend to do that.
We understand the distinction, Your Honor, and we're strictly going with a Bowden defense.
Okay, so you can get into third-party culprit with Brian Higgins, that the police were aware of whatever you're going to argue and failed to act on it. But it's strictly for that purpose, okay?
Yeah, I understand. That's crystal clear.
Okay.
And that's really what I was seeking, this clarification.
Yeah. So Mr. Yannetti, and of course I take him at his word, tells me that they're not going to do pure third-party culprit. Okay, that's great. That makes that easier. So I will give, sure, go ahead.
While we're on page 8, I just wanted to, Commonwealth does have an objection to the teaching instruction that's at the top of page 8.
Yeah, I have a check mark next to that. Ms. Giannetti, tell me about this, the absence of a recording. Are you saying that the police should have recorded Ms. Reed at her parents' house?
Right. So, obviously it's not the strongest DG Batista argument that we would have, does not occur at a police station, but, these days, Your Honor, it's common knowledge that everybody has access to a recorder, even on your own cell phone. It could have been done. It wasn't done. We have to rely on police memory of what my client said or didn't say when there was a possibility for a recording. So we still think we're entitled to.
Do you think it was custodial interrogation? Or I guess I should say, do you think the evidence supports?
I think there's an argument that it was a custodial interrogation. We had police officers who, used to sit down in the living room. They were surrounding her. Someone who is not familiar with dealing with the police at all. So yes, I think there's an argument that it could be considered assault.
All right, what do you say about all this, Mr.
And
Allen?
I would also add, Your Honor,
Sure.
they did seize her vehicle at around the same time. So, that it goes to the issue of custody and my client being able to deny it.
All right. What do you say?
That's the very nature of the objection, Your Honor, is the non-custodial nature of this. So the troopers spoke to Ms. Reed at her parents' house, as they did with a number of different witnesses on that day as well. For the course of that day, they spoke to her while she was seated on the couch in her parents' living room. The parents were present, no one was restricted from eating. And it did not end in any sort of custodial situation. She was taken into custody, she was arrested. Yes, they did seize her cell phone and her vehicle, based on information that they developed from the course of the day, and from statements from Ms. Reed herself. But I don't think that transforms that conversation or interview in her parents' living room into a custodial interrogation. The bigger issue that I have placement, as far as there's already been within saying request for jury instructions or request for humane practice, and then following the DG and Batista language in the defendant's request for jury instructions, there goes on to all of this other requests regarding her compromised mental state and all of these other things that, while if it were to be given by the court, should be given in the same context of humane practice. I don't think it's something that should be highlighted in two different sections. I would submit that there is no evidence of her having a compromised mental state or anything to that effect. She exercised her judgment as far as when she was speaking with Sergeant Lieutenant and have this testimony from the stand, that initially she said she wanted to be fine with answering questions, but they wanted any details. And then when the questions became centered on, more centered on details, at that point, I know that's not a jury, but of course, where she then ended the questioning at that point. So I don't think there's any evidence of her having a compromised mental state during the course of this interview. And I don't think that arises to the level of the instruction. So I would ask basically that everything on page 8 prior to the open instruction be excised.
All right. I'll take another look at this and I'll just let you know in the morning.
And Your Honor, with regard to the compromised mental state, we agree that that would not apply to the interview at your residence. But we believe that it applies in the humane practice context.
That is where it makes sense. So, all right.
If it's going to happen, it should happen once, not.
Yeah.
I think that's fair.
Okay. Okay. All right. I'll take another look at this and I'll just let you know in the morning.
And Your Honor, with regard to the compromised mental state, we agree that that would not apply to the interview at your residence. But we believe that it applies within the humane practice context.
That is where it makes sense. So, all right.
If it's going to happen, it should happen once, not.
Yeah.
I think that's fair.
Okay. Okay. All right. Prior statements, I will give some instruction on prior inconsistent, and I'll give a prior consistent statement. I will talk about the view. The absent witness instruction is withdrawn. So is the,
Not to interrupt.
That's okay. That's okay.
With regard to the Your Honor, we didn't get a right to reinforcement to the fact that he dropped that they saw him.
Oh.
He was not present on January 29th. That no sense.
Okay, so I did not see this when I took a quick look at the view. All right, I'm not going to repeat it. All right, lost or destroyed evidence you're withdrawing. Direct and indirect evidence. I'm going to try and give a shorter instruction on that. So even the one I gave is too long. I'm trying to cut down the time the jury needs to hear general instructions that I think they're perfectly capable of hearing in a shorter period of time. All right, thank you. Credibility, the same. Law enforcement witness, I think I gave some instruction on that. I'll include that somewhere in it.
If I might just reference that.
Sure.
Any language in there I rejected.
Okay.
That's when a police officer or someone else works for a law enforcement agency.
What do you mean by that?
I think that was taken into account for the dispatcher, perhaps. We're not.
Yeah, I'll do police officer because they're police testimony. I'm not going to go beyond that.
I think that.
Okay, thank you. I'll do the photographs, the opinion testimony, notes. I'm not saying I'm giving exactly this, but I will give, I'll cover all those topics.
If I might just, as far as the photographs,
What page you on?
16.
Okay.
One suggestion there was indicates Commonwealth has introduced photographs and evidence. I would submit.
Yeah, I'm just going to say there are photographs that are in evidence. Was that the nature of your objection?
I actually think that defense has introduced more graphic.
Yeah, so
photographs.
I would just say you've seen photographs.
Fine with that.
Or there were photographs and evidence. I instructed twice anyway, maybe 3 times on it. So I'll give some version of that. Juror notes, I'll give some version. The implicit bias instruction, I'm going to give exactly what the SJC told me I should give. All right, so the Commonwealth's requests are sort of in the, you start with the law and then you get into the general instructions, Mr. Lally. So let's skip to it's not numbered, your supplemental instructions, use of a dangerous weapon. All right, so I'm going to give that, Ms. Giannetti. I gave a dangerous weapon instruction last year on the motor vehicle.
Understood.
All right, so I'll give probably what I gave last year, and this looks like it's it. What is not evidence, evaluating, I'm going to give what is not evidence. Evaluating the evidence, there's some instruction. Ms. Giannetti, what do you think about the short instruction on jurors? It sort of makes sense to me after such a long trial. No juror is better qualified to determine the truth of the facts in controversy or to deliberate upon a verdict than any other juror, or solely because of that, solely because of that juror's occupation, education, experience, or any other characteristic. Okay. Thank you. Charts and summaries, I'll talk a little bit about chalks. And inferences, I will give some. I'll give the redacted exhibits instruction. Witness preparation for trial. Do you both want this? There was testimony on both sides. It's simply, there was testimony at trial that the attorneys, and I may say if you find or something, preface it. Witnesses when, the attorneys interviewed witnesses when preparing for and during the course of the trial. You may not draw any unfavorable inferences solely from that fact. There is nothing improper about conducting such interviews. On the contrary, the attorneys are obligated to prepare their case as thoroughly as possible and may interview witnesses. I don't know if there's a sequestration order, if this is appropriate though, where it says during trial, during the course of the trial. I'll just say when preparing for trial.
Yeah, we're joining in the request. I don't know that we included that in our instructions, but we're joining in the Commonwealth's request for that instruction.
All right. Okay. Expert witnesses, electronic communication. So I'm going to go through the limiting instructions I gave. I need to just do this again here. So electronic communications, I have that on my list. The emotional impact photos, humane practice. We'll get back to consciousness of guilt in a minute. I'm also going to give the prior bad acts instruction. I did that in regard to the Aruba incident, if you want to call it that. I gave a prior bad acts instruction before that testimony came in. I also gave the instruction that I will also give on the state of mind of John O'Keefe as to his state of mind being known by the defendant and the likelihood that she would act on it. So Commonwealth versus Bins in those cases.
Your Honor, with regard to Aruba, we don't believe that there was really any testimony that came in.
I thought it came in through Kaylee. I should say it did come in through Kaylee. That's when I gave the prior bad acts instruction. She testified. Okay. All right. So did I give it any other time that there's another event that I should highlight? I don't think so.
I don't think there was an instruction at that point.
All right. I think I have to add that here. So, all right. And I will look at it and decide whether I need to add it specifically. It might be covered enough. Might be covered enough when I give the electronic communications instruction. So I will think about that. All right. Those were the limiting instructions I wanted to get to. So
We would object to the part of that act being linked to the Higgins text message.
all right. I'm going to take a look at that, Mr. Lessie. All right. Consciousness of guilt.
Your Honor, Commonwealth.
Okay. All right. All right. So tell me where the difference is in what I gave last year from the model homicide instruction on second-degree murder and where you're saying I should not this year, Mr. Lally.
Your Honor, so the only,
1 second. Let me just pull that up. Okay.
Your Honor, Commonwealth's request is merely not for any change or alteration in the instructions that were given, other than there are three prongs of malice, and essentially the Commonwealth is requesting is that the jury be instructed
Speak up.
merely on third prong malice, as that's the only one that really applies to these factors.
Okay.
The Commonwealth here, the first two prongs are essentially extraneous in this situation, and don't see explanation to avoid confusion.
Do you have supportive case law for me to single this out?
I do.
What do you say, Ms. Giannetti?
I mean, Mr. Brennan essentially stated that in his opening statement.
Stated what?
Well, in his opening statement, he stated that he's not alleging that she intended to do him grievous bodily harm, not intent to kill him. And it was just the third prong. He stated that in his opening. I imagine that's what he'll likely argue in his closing. You know, I don't have a position on this. I just don't know, and I think the court's going through this analysis in your head as well, whether it's permissible or not. I just raised that as an issue, but I don't have strong feelings about it.
I could say the parties agree that the first prong and the second prong are not applicable here.
I think we're just at a position where we'll refer to the court on this.
Well, I'm not going to say you agree if there's no agreement. If you can get me a case by this afternoon,
I will endeavor to do so, Your Honor. We will. I don't have anything.
I'm inclined to go with the model. I'll see if there's something I can find. You're probably better at finding it than I am, Mr. Lally, but I'll see if there's something I can find to support the position that it's just the third prong, and therefore I only have to give that instruction. I don't think I'll find anything, but let me see. Because I can understand why both of you don't want it. just let the jury focus on what they need to focus on.
That's really the only reason for this, but I understand, and I don't.
You know, I suppose I could always tell the jurors that the Supreme Judicial Court has come out with jury instructions that I must give in their entire format. And that sort of explains why I say something that doesn't apply, maybe.
I wouldn't mind. We wouldn't have an objection to that.
Maybe I'll do that, but let me see if I can find something. If I can find something that says I don't have to give those first two prongs, I'll let you know before you begin. All right.
And Your Honor, before the court makes a decision on that, we see what the court is proposing if you are going to alter the count.
If I alter it, it means I remove those two. That's all.
Right, no, we just wanted to.
Yeah, sure. My guess is that won't happen, but we can see. All right. So lesser included offenses. Did you want to know UI instruction? You were.
We're asking for that.
Okay. All right. Right, I think that's it, aside from Mr. Alessi's motion regarding the exhibit. Right, is there anything else that we're missing?
Just a couple of other issues. One is with regard to the Proctor text messages, we have a redacted version now, which we'd like to submit to the court on a copy to the Commonwealth. You recall that we had agreed essentially on a redaction subject to the court's rulings.
Okay,
But it wasn't in final form. We believe it's in final form now.
and you all agree that it's in final form?
Well, they haven't seen it.
Oh,
but I'm going to
okay.
give it to them now. Can I hand this to the court?
Sure, thank you. All right, so
The only other issue, Your Honor, is we do have a.
hold on one second on this issue still. So I will give the Commonwealth this afternoon to take a look at this. And tomorrow morning, if you don't have agreement, then we'll have to deal with it. And I'd prefer not to have to deal with it. So,
I'm sure we can be in touch this afternoon. I do not believe there's going to be any problem.
okay.
Just a couple other things before we get to Mr. Alessi.
Yeah.
One is that we do have the Dr. Wolf PowerPoint to be introduced to the evidence on.
Dr. Wolf or Dr. Rentschler?
Dr. Wolf.
All right. And this was allowed into evidence unobjected to. I thought we already had it. We didn't.
We have to redact it, so. we
Okay.
redact it. It's on a thumb drive.
Okay. And the Commonwealth has seen it? All right. So they'll have to see it. So Mr. Lally, Mr. Brennan, Ms. McLaughlin, one of you has to take a look at it.
And then, will the court allow more than an hour?
I'll allow more than an hour. I'll allow an hour and 15 minutes.
Thank you.
All right.
And I think I did mention that we had a proposed verdict slip for count two, Your Honor, if I didn't.
You did not.
Okay, we do have one, we've got different copies to the Commonwealth. Can I hand the
Okay.
proposed copy to the court?
Sure. Is it the same as last year's, but now with a?
It's different.
Okay. All right.
You'll have a chance to digest that.
Oh, I digested it, Mr. Alessi. Go ahead, I'll hear you.
I'm actually in that.
Yannetti, jeez, I'm sorry.
So, Your Honor, you'll recall, we had some spirited argument both before and after trial regarding this particular issue. And our concern, Your Honor, was that it's obviously a confusing indictment because of the number of lesser includeds and the number of elements that are different for each lesser included. And we were uncomfortable with, there being one option for not guilty at the top of the form, and then multiple options for multiple different types of guilty verdicts throughout the remainder of the form. So what we have done is to fashion this in a way where the jury
pursuant to the court's instructions, would first decide the offense as charged, and if it's a guilty verdict,
Madam Clerk?
The analysis is over. If it's a not guilty verdict, they go on to the next lesser included offense, and again, same analysis applies. If it's not guilty, they then go to the next until they finally reach the final verdict, which the lessest, or the least, I should say, of the lesser included offenses is simple operating under the influence, where they have an option for not guilty or guilty. We've also changed a little bit of the wording, you'll see, which I think makes it clearer and less confusing. When the jury is given options for theories of guilt on at least one, two, three of the charges, including the main charge, because there's this issue of either under the influence or 24 weight or greater. The way it originally read, Your Honor, manslaughter while operating a motor vehicle under the influence of alcohol was repeated twice. It was repeated once where there's an option for guilty, and then it was repeated again with both of the other options. We think that this is simpler, it's cleaner, it's clear, and we believe that this verdict slip is the most appropriate one.
Mr. Lally?
Your Honor, as the court is probably well aware, the Commonwealth is not requesting any lesser included, and I certainly understand that if the evidence supports it, the defense requested that the court was given. Having said that, the verdict slip that was used in this matter last year, the Commonwealth submitted is more than sufficient and adapted to the defendant's request. The only other thing I would bring to the court's attention, I don't know if you're aware, there was a case recently, while this case was going on, tried before Judge Law, in which he had similar issues. I believe used at least part of the verdict slip from the first trial, in this case, as sort of a template for the lesser included that he instructed and the verdict slip that they utilized in action. I don't have a copy of it on me, but I can certainly get the court a copy of it. But that may be somewhat helpful, of course.
Okay, was that on murder case?
It was not, but it had to do with a felony motor vehicle homicide.
Yeah, I'll take a look at it.
Mr. Turk.
Mr. Turk. Mr. Yannetti, I don't believe I'm going to give this, but I'll take a closer look at it.
Well, we appreciate that. Judge Lau is an excellent judge. We think that this verdict slip is, it provides the most clarity for the jury. That's why we're.
Okay, and that's where I think we disagree. So I will take a closer look at that. And so has it been filed officially and docketed?
I just handed it, I believe.
All right, so Madam Clerk, you have a copy up there?
The proposed, I think this is the only copy.
Okay, that's what I was wondering. Okay,
Do you need an extra copy? Please?
sure.
This is the
Yes. Or, you know what, just mark it for identification, Margaret. We'll do that. Chrissy, please. Just for ID.
It's LLLL for ID.
Thank you. Mr. Lally.
Your Honor, just one request, circling back to the constitutional instruction. So Commonwealth is withdrawing its request for the instruction.
Okay.
However, would be seeking to make some argument or reference in the argument to the jury related to specific areas which we would need judicial approval before we did this. So the two areas that are sort of listed within that we would like to make some argument to the jury regarding is the defendant's taking of the Lexus from one metal that came to her parents' residence indictment, and then certain statements made in reference from the various clips of the play of her statements.
Okay.
In particular, would be the one where essentially she says it's identified to her.
Okay.
Whatever the exact.
All right. Mr. Yannetti, do you want to weigh in on that?
Yes, really, objective to that. I don't see it's her or me being evidence of consciousness of guilt. And the notion that she's driving from one residence that the police know of to another residence that the police know of, which is her parents' house. The car is open and obvious in the driveway. In fact, when the police call, she says, yes, come on over. I don't see that as being any evidence of consciousness of guilt.
Okay, so I'm going to allow them because they're permissible inferences from what's in evidence, but I'm not going to give, even before it was withdrawn, I wasn't going to give a consciousness of guilt on those.
And just to be further clear, there may be other clues.
Yes, so I did want to ask you though, Mr. Yannetti, I think it's an argument that can certainly be made by the Commonwealth regarding the video clips that your client gave during various interviews. I think consciousness of guilt is a permissible inference from some of those. Are you sure you don't want me to give the consciousness of guilt because it's got helpful language for a defendant in it as well?
No, we
Okay,
do not like it.
okay, I just wanted to give you the opportunity. Okay. All right, anything else? Anything else, Mr. Yannetti? We're going to hear from Mr. Alessi, but
The Commonwealth does not object to the redactions.
that's great. Thank you.
Excellent.
One less thing you all have to do today,
And
okay?
this is Mr. Ellis.
I know. All right, so let's make that, are we switching that new redacted version with an exhibit number? Do we know what it was before? Excuse me. The redactions on the Higgins messages, that's what you're saying you're fine with, right?
Proctor Communications.
Proctor Communications, okay.
Right, this is the testimony that came in.
Of Proctor, yes. All right, so we'll find the exhibit number and we'll just, 209, is everybody in agreement that it's exhibit 209?
Yes, sir.
Okay.
Does the court have a copy or do they need the Commonwealth?
No, I wrote on it. I need the Commonwealths.
So this is a clean copy. This one.
So that will now be 209 in evidence. You know what? Can we make that 209A? We need, Mr. Yannetti, we need to keep record of the first one that was not redacted. So any objection to making this 209A?
No objection to that. And so original 209 will not be sent in. Is that?
It becomes.
What do you think? Yeah.
I-
Yeah, so we'll switch it back to ID and this will just be 209. All right, did we have an ID number on it originally? Can it still be that?
Is it redacted, the NNN, or is it, no, it can stay there,
Okay.
right? 'Cause this is the-
Oh, it's just NNN, it's not,
Well, where did it?
no, it became 209.
So that has to
Our
be-
thinking is it needs to be sent back to letters for ID. I think.
Yeah.
So it'll be marked MM for ID.
That's great.
Perfect. And then the redacted version will now just.
209.
Yes.
Yep.
And we'll hear from you this afternoon. Just somebody send us an email to the clerk's office. So someone send an email to the clerk's office today letting us know if the Wolf PowerPoint is ready to be put into evidence after the Commonwealth looks at it. Okay, so we'll take care of that. All right, Mr. Alessi, I'll hear you.
Thank you, Your Honor. If I might suggest respectfully a procedure to the court, I have spoken with the Commonwealth about what the topic is. It's obviously not new to anyone, but perhaps to expedite this matter, if I might suggest to Your Honor to avoid a more lengthier argument, it might even truncate it down to 30 seconds. If we could hear from the Commonwealth on what we have requested, and the topic specifically is entitled Defendant's Motion for Curative Instruction regarding Exhibit 88 and Introduction into Evidence of Exhibits. The exhibits is taken care of. That's no longer an issue. But I did speak with Mr. Lally, and if I could suggest that Mr. Lally can state his position as I understand it, and then I can go from there, and it may not be necessary for me to continue on.
All right. What's the Commonwealth's position?
So Your Honor, Commonwealth's position is ultimately for the court as far as whether or not it's appropriate instruction to give in the final charge. What Commonwealth will submit is that the contemporaneous instruction was more than sufficient to address the issue, and that it doesn't require sort of differing language for further instruction given the jury during the court's final trial.
All right, I'll hear you, Mr.
Thank you, Your
Alessio.
Honor. May I go to the podium?
Yes.
Thank you. Your Honor, I have given, and Your Honor has provided me previously with a generous opportunity to be heard on this, but I do need to cover some points with regard to the matter. I was hoping to avoid doing this, but given what we just heard, it needs to be done respectfully. As Your Honor knows, we have submitted this motion, and as part of the motion, it really consists of two parts. The first part is the text and the basis for what we're requesting. I'll come to that in a moment. And then attached to it are is Exhibit A and Exhibit B, and those exhibits are our best effort at transcribing, because there's not an official transcript at this point of exactly what happened. Why do we put in the exhibits? We put in the exhibits because we believe it really sets forth and illuminates quite vividly what occurred. It occurred rather rapidly, but I think this allows for a much more these exhibits allow for a much more reflective analysis. So just briefly, what, as we know, happened is Attorney Brennan took Exhibit 88 encased in whatever the plexiglass material, had it set up, and we understand this now in retrospect, behind the witness stand. And then at a certain time in the cross-examination of our witness, Dr. Wolf, confronted Dr. Wolf with it as part of an accident reconstructionist cross-examination, and challenging Dr. Wolf on several aspects. And this one was particularly apt that the subject matter, not the manner of the examination, was, Dr. Wolf, you're saying this, these are your theories. However, did you consider and take into account the holes in the back of the hoodie? And that led to a series of questions and a series of answers. And I want to go right to the end, because I think going right to the end better elucidates what actually occurred and the depth of the issue and the problem here in this misconduct, which we believe was intentional. Specifically, the end is, we know, and I believe it is completely undisputed, that the holes in each and every hole in the back of the hoodie was caused by the criminalist, a witness in this case, Ms. Hartnett, who made those cuts as part of her analysis. And that was in May of 2023, long after the alleged incident of January 29, 2022. So that's sort of the end, undisputed. Now let's go back to what happened in the examination, the cross-examination of Dr. Wolf. So he's confronted, and I think, we put in Exhibit A and B of it, but what is particularly striking is on page 7 of Exhibit A, and it's the colloquy that starts in the middle, which we've yellow highlighting, Attorney Brennan saying, when you were making that opinion about consistent or inconsistent, did you ever consider whether there were holes in Mr. O'Keefe's sweatshirt other than the right arm? Dr. Wolf started to answer, well, I know that there was cutting to, and I emphasize cutting, and then he was cut off by Attorney Brennan. And Attorney Brennan said, may I approach and receive the exhibit, Your Honor? And we note that in the context of many other statements in this regard as to what happened. So now this comes to the requested relief, and I'm going to move to the part of the argument, Your Honor, that we believe respectfully compels what we're requesting. So now I want to just state what we request. We believe it's what we've requested is quite modest given what happened. And our proposed curative instruction is on page 2 of our motion. It states, during the cross-examination of Dr. Wolf, Mr. Brennan asked Dr. Wolf about holes in the back of the sweatshirt, Exhibit 88, falsely insinuating that those holes were sustained on January 29, 2022 from a fall backwards. I instruct you that those holes were not present on January 29, 2022. Those holes were made by Maureen Hartnett, a criminalist at the Massachusetts State Police, I've got the acronym MSP, Crime Lab, in the course of her inspection and sampling of the clothing on May 18, 2023. Dr. Wolf correctly testified that those holes did not come from any alleged event on or about January 29, 2022. Please juxtapose that with regard to the instruction Your Honor had given, which was a sentence, so jurors, I instruct you that those holes were made by the criminalist, Ms. Hartnett, during the course of her inspection and sampling of the sweatshirt.
Didn't I include the date you requested, the May 18th date? I thought I did.
You know, Your Honor, I think the answer is no, but because I'm doing it from memory and I don't.
This is not an official transcript, right?
Exactly, Your Honor. So I can't say it with certainty. I don't believe it was.
Okay, because that date you told me was important to you, right?
Among other factors, the date was important.
It's May 18th, right?
Yes, Your Honor.
Okay. Go ahead.
And so, Your Honor, I believe what is fair in the analysis and as objective as I can be here is, I think the curative instruction has to tether to and relate to in its details the degree of what happened. This was on a very significant topic, accident reconstruction, a significant piece of evidence, the hoodie. There's been much discussion among many expert witnesses about this hoodie, what it stands for. There's been videos on it. You know, our position, the hoodie in a proper accident reconstruction would be completely unaffected by any alleged motor vehicle incident. And then to show the witness on this for the defense, it clearly left the impression to any objective observer that Dr. Wolf had somehow been incompetent, which is 180 degrees of the reality, but also that he just wasn't otherwise diligent, and the jury therefore should not weigh and value his opinion. This is very, very significant. And I underscore, Your Honor, we didn't cause this problem. We didn't cause any of this issue. So to me, I do not understand why the Commonwealth would not support this. What we have written down here supports the truth. We all, I believe, should have the common goal of the jury receiving the truth. I looked at the jury. I'm no soothsayer or mind reader, but I looked at the jury and they looked confused when I looked over at them. But I think even aside from looking at a jury,
What Your Honor did in good faith, I don't believe is clear enough on this key issue. And I'm not understanding why there would be any real contest over making it clear to the jury on this very important point. The defense, to my point of being measured at the time and being measured now, we could be requesting a lot more statements about what occurred. And I've been in situations in other trials where things have happened and there's been many more significant things stated. So in conclusion, Your Honor, the defense not having contributed at all to this issue, the significance of the issue, the significance of the error, it's undisputed about the error, to me, respectfully, all augurs for more clarity here. And the final point, there's two issues here. There's the fact of when these holes occurred, these cuts, and how they occurred. That's one bucket. But the second bucket, which is not in the current instruction, is our expert witness, Dr. Wolf, and the impression left upon him. And that is why we have the language in there. Again, we believe quite measured, just the sentence at the end to take care of the harm to our witness with regard to what occurred. So therefore, Your Honor, we respectfully request that this be given so that the jury has a clear and complete and truthful understanding of not only what happened, but also to make sure that it is what's created for the jury is accuracy, hence truth can be concluded. Thank you, Your Honor.
Thank you. I do just want to point out one thing. It was not objected to at the time it came in. That's my only comment. I will consider this. I'm going to hear from Mr. Lally. I will consider this.
What is it that was not objected?
The testimony was not objected to. I didn't hear this until I think after another witness.
Your Honor, if I could, just thank you for raising that. 10 seconds for that. I will, and I made this point the very time that I made the argument last time. We were not shown that Exhibit 88 in the encasement. It was behind the witness. We didn't even know that it was behind the witness. So what happened was Attorney Brennan went up, retrieved it, and immediately went to the witness with it, showed it. We couldn't even see what was happening. There was no physical nor other ability for us to object at the time. So I appreciate you giving me the opportunity to respond to that.
All right, Mr. Lally,
Very briefly,
keep your voice up. Please.
Yes, very briefly. I'm not going to get into a belabor of the point as far as the back and forth about conduct of counsel. During the heat of trial, during the heat of the extended exchange with a witness on the stand, things can happen. Mistakes can be recognized, acknowledged, and accepted as a mistake. There were numerous offers by the Commonwealth to offer a stipulation as to the truth as far as the evidence is concerned that were rejected by the defense. They wanted the curative instruction. They got it contemporaneous with when the evidence came in. There have been many instances of similar type conduct that didn't result in a curative instruction, and to accentuate it further in the final charge to the jury is simply improper. It was a situation that arose as far as whatever misstatement was made at the time, as far as whether it's from the testimony from the witness or the question from counsel, was immediately remedied, was taken care of. I don't think that there's any confusion by the jury. And furthermore, as I indicated, the Commonwealth offered a stipulation at the time that this occurred, which was essentially rejected by the defense. They got the curative instruction at the time. That is all that is required. It is more than sufficient, and it doesn't need to be accentuated or addressed further in the final charge.
Okay. So I'll consider it, Mr. Alessi. Okay?
Thank you, Your Honor.
All right. Anything else? Two things I'd like to talk about for scheduling. the jurors get here early, I'm going to ask if the court officers to call the jurors and ask them two things. To ask them if they can get here a little bit earlier so that we can all be in the courtroom at 8:45, ready to start. So things take a little while generally. That will assure us the closing arguments will start right at 9, maybe a few minutes earlier. The goal would be to hear arguments from both counsel and then take an early lunch break. I would ask that counsel plan on just a half an hour lunch break. I'd like, the point being, I want the jurors to start deliberating. I don't want to end the charge and send them home for the weekend. That's not fair after they've waited so long. So a short lunch, you're free to stay in the building and court officers will help you with accommodations for that. But a short lunch, and then I'll come out and do the charge. And then at least hopefully there'll be some time for them to deliberate. I'm going to ask the court officers to call the jurors to see if they can stay as late as 5 o'clock or 5:30 tomorrow night. I just don't think it's fair after they've sat through so much of this trial with the various delays that we've had to not let them start deliberating.
We have no objection to that. One request we have, Judge, is during the last trial, during the deliberations, the court had asked us to be within 5 minutes of the courthouse. My office is about 10 minutes away.
I'm sure we can make accommodations for that.
Okay.
But at some point, we may have to talk about security issues. So a lot may depend on that.
Understood.
All right. Does the Commonwealth have any objection to that schedule?
No, Your Honor, none at all.
All right, so we'll see counsel in here no later than 8:30 tomorrow morning?
Sure.
We'll counsel here at 8:30. All right, thank you.
All rise for the court, please.
Is there already one of these? Like, are we swapping?
Yes.
Goodbye.
Well, hello, everyone. I came in just at the right time, didn't I? Actually, I've been listening the whole time as Michael Bryant's been holding down the fort here. I see his avatar there. I know he's close by to look in. So now we know at least the schedule. Hi, Michael Bryant. How are you?
Gone. I can't get my butt out the door. Yeah, so I was listening in, and of course, never believe what you hear about the whole, oh, they're going to go to 7 o'clock.
Well, but she is going to 5 or 5:30.
Yeah,
so,
maybe
yeah.
5:30. So, whoever
Yeah.
came up with that was dead wrong.
But they're starting to make up for it. They're starting earlier. Counsel have to be there at 8:30, and they want the jury. That's what I just heard. They want the jury in the box by 8:45, so they start by 9. Is that what I heard?
Sure, great.
How
then
big-
we
how
can take
big
an
to put
early
the
lunch
jury
of
in the
only
box
30
to-
minutes. It's all just a
So
dream.
an hour. So
It's a dream.
well, let's see. Let's calculate this. An hour and 15 minutes. That's 10:15. Then they have to take a morning. Everyone has to go. As we heard, if you listened to Aiden's interview of juror number 3 last night, which was fascinating. If you haven't, they have to go take their. They have to all pee and everything. Okay, let's be honest about this. So that's 10:45, and then they come back in another hour and 15 minutes. 11:45. That's noon, and then they're going to take a half an hour lunch break. Then she's going to charge them, or they're going to take a half an hour lunch break. That's 12:30, and then she's going to charge them. That's till 1:30. So they could be deliberating this case by 1:45 tomorrow, and then go 2:45, 3 hours, 3.5 hours. It could be.
She's doing everything she can without getting into overtime for the court staff, which she's not approved to
Which
just
she's not approved
allow.
to do. That's right. That's exactly.
She's trying
what
to
it
give
is.
them every minute to get this thing done on a Friday afternoon. So if you want a Friday verdict, she's setting it up as best she can.
Yeah,
So.
yeah, that's it. Well, you know what? If there's a Friday verdict, it may not be bad for Karen Reed because you have so many. The top charge. What I heard the most ridiculous thing is apparently the first 2 prongs of the top charge don't apply, and Mr. Yannetti said even Mr. Brennan didn't say he was going to argue them in oral argument. She said, well, if you both agree, maybe I don't agree with them. But the Supreme Judicial Court says maybe I have to get it. No, you don't. If the attorneys both agree, you don't have to give them.
And it's not, and I mentioned that yesterday. That it's not on you, Judge. You're just you need to protect your record for appeal. If they agree, it's a winner for you. You have no problems.
You have no issues at all. And then the other thing I heard that I wanted that I thought you probably I knew you would die with this one. that they give a more complete slip, or as a verdict sheet, as we would call it in every
Yes,
other
the verdict slip.
jurisdiction. That's where you fill it out. So that it would not be confusing to the jury. And she says to Miss Fietta, "Well, I glanced at, I looked at it. I don't agree with you. I mean, normal the verdict sheet says, okay, if you find a not guilty on count one, you stop, and then you go to count two, right? You're finished on count one. If you find a guilty count one, then you don't need to go to count two. You may need to go, then you drop to count three. Or if you find a not guilty, and then there's also, I gather the defense gave an instruction, a proposed instruction that said something like, you could find if you're hung, tell us on any count, right? That's what it sounded like. And she said no, is what it sounded like.
They tried, as I've suggested bazillion times, to clarify that whole confusion that began last time that led to, do we have unanimous decisions on anything? Does that matter? Does the court care? And they're going to get the same jumbled up, confused mess that they got last time. A verdict form that is not a if-then type verdict form, which is what you should have. It's so simple to follow. They're going to have all the lessers included, and they're going to have various not guilties placed here and there, various spots on the form. It's subject to the same kind of confusion, misinterpretation, and error as the last time. So she's learned nothing.
Yeah, nothing. She had a very nice demeanor today.
It was great. I was saying, if somebody just tuned in, if somebody had not been watching this case or the last one, the whole trial, they tune in and they go, "Oh, isn't this a lovely?"
I try to get my camera right.
Isn't she? Isn't she just lovely the way she's? Oh my God!
And you notice that this is the same thing, Inspector. When I was preparing for final argument, closing argument, you see the two lead attorneys who are going to do the closing arguments don't appear for the jury charges. That you send others because you're busy preparing for closing argument. And Mr. Yannetti is much more familiar with Massachusetts law in terms of jury charges anyhow. So I did the same thing, Inspector. We in Hernandez, we all sat there because while we had local counsel, we felt it was important for us to be there. But then the judge gave a break to get ready for closings. The difference here, gave a break. You have a day.
I thought, you guys correct me if I'm wrong, but I thought Brennan was sitting there.
I didn't see him there. Did he not?
Yeah, I thought I saw him just immediately to Lally's right in his normal chair.
Maybe I didn't have. I did. That I had to get new glasses this week because I couldn't find my glasses, so they rushed them on Monday to get them Tuesday. And when I just drove back up to the cabin here, which is where I'm working and streaming from for today and tomorrow, because I figured if I was to be comfortable, we got our 11-hour day, right? I found that I had run them over. And all. So maybe my new glasses aren't as I'm not used to having fresh new lenses that I can see.
Actually seeing. Yeah, I see. People are confirming that he was there in his normal spot. And even when he doesn't talk, I hear his voice. It's weird.
The funny thing is I didn't see him there. Jackson definitely wasn't there, right?
No. In fact, the court clarified that they were standing in for Mr. Jackson just to make sure she didn't start without him. Yeah, she did the whole introduction of every individual attorney and Karen Reed, all of that formality that she did during jury selection, and then totally abandoned for a counsel. Ms. Reed, here we go.
Sorry, guys. I didn't see him, but maybe it's because I was rushing down on my phone and my new glasses and all.
Well, he blessedly said nothing. I thought there were going to be times where he would step in and further embarrass Lally, by taking over. Because there were some important issues that Lally was arguing, and Brennan didn't say anything. So.
Hey, Tom Barnes says, I just see it passing by. Would you do a mock closing argument? We did 30 seconds of mock closings on either side. I had to take the prosecutor's argument.
You did the tough one. In my opinion, you did the tougher one.
Yeah. And it was short because I didn't really want to say too much. But just so you know, it's on our last night's stream. With Neil Rockheim, if you haven't seen, who did a great closing argument, along with Michael Bryant, who did a great closing argument for the defense, the two of them. And then we had our accident reconstructionist, Stephen Plordon. He worked for the highway, 45 years in law enforcement. And he says, there should be a not guilty. He's been saying there should be a not guilty ever since Welcher testified. Should be not guilty. Yeah. Not guilty. And he's independent. He's really independent.
He really is. And some of his colleagues have been soundly, criticized in this case. So He's not
No
a fan
fear.
of everything that's happened, but he's looking at the case as anybody should, common sense, weighing what they've seen and heard, and he says, not a chance in hell. I don't have
No, I
that
have
much
to.
optimism.
I know. No, I know that, but you and I talked since the last trial, all right? And let's pat ourselves on the back a little bit. We both said that they would have been better going off for the issue of no collision, didn't happen, that the burden of proof, abandoning the third-party defense, except as you can argue that the police investigation was bad and they don't know what happened and this could have happened and that could have happened and all.
Yeah.
And Michael Bryant, that's exactly what the defense said they were doing today.
Yeah,
Congratulate yourself. Pat yourself on the back.
It's actually a nobody knows what happened defense, and there's only one conclusion if nobody knows what happened. So,
That means
and why don't they know what happened? Because of the Baden defense,
proof.
inappropriate investigation or lack of investigation. So
I have to tell you something. I have to tell you something. A couple of weeks ago, I think I thought, and I even said last night that I thought that it could be, you still could have a hung jury on the second count. If it's going to hang, it's going to hang on the second count. Okay?
Sure.
And I still believe that if there's a possibility that it hangs, because you never know what a jury would do. I would advise everyone, and I know I was texting like crazy to the whole team last night, to listen to Aiden Carney's interview with juror number 3. She was the one who was kicked off the last day. And it turns out the 3 women who didn't deliberate, that were kicked off, were all not guilties for Karen Reed. She confirmed that. They were all
that is a huge major difference in this trial. We still got 18 bodies, right?
Right. They want to be there.
We still got 18 bodies, which is interesting. And they're going to be mad. There are going to be 6 people that are very mad. But maybe we can get one of them on.
Oh, I'd love to get one on. But my point was that all of you should listen to it because it was fascinating, because she was a clear not guilty all the way through the last trial, even though she thought it was a mess. And some of the stuff that she talked about was fascinating, like how they got rid of their phones, how Brian Albert didn't come out to see a dead body on his lawn, all the things that made it kind of a mishmash, right? But this time, but she thought that the defense had missed an opportunity to convince other people, right? This time until May 29th, as it turns out, she has been communicating with Aiden Carney. She thought that she was on the fence, and she actually was more leaning towards the Commonwealth, still not saying guilty, but she thought that once they put on their case, completely change. Not guilty, not guilty, not guilty. That rammed it home, and she was very strong, because it was interesting to hear what jurors do that you can't believe they do. Okay.
Yeah. And remember, I mean, the perspective, of course, is as unique as it gets. It's unfortunate she wasn't actually a deliberating juror, because that would add a whole nother level of understanding as to what was going on in this case. She heard a lot of it secondhand. She's apparently had some contact with those that did deliberate.
Right.
Right.
She has.
So she got some insights, Bowtie Ronnie, as I call him. She doesn't think he's being truthful in some of his interviews about how he really was voting or feeling about voting.
Right.
So
yeah, but it's fabulous to go listen to. She did say that she thought that she didn't know whether she could get them to not guilty, but she could have an effect of swaying some people. Blessed in Texas, thank you so much for that.
Thank you so much. I got to go
for
gas
Michael's
up.
Trip. Yes, all of you have supported this week is all for Michael's trip coming up. Do you all think Welcher purposely shot his integrity for money? Otherwise, he's an idiot that founded a company that survived long enough to be bought out. I think he sold soul.
Yeah, I think there was such a critical point when Rentschler testified about the fact he's a salaried employee, because nobody has ever heard of an expert that isn't, part of the cross exam is how much are you making and what did you charge? And, it's kind of lame, but we hear it all the time. But you don't hear, oh, I'm salaried, I don't really deal with the financials. And that comes on the heels of Welcher, who I don't recall that we got into specifics about how much he made.
$435,000, but that didn't exclude his testimony and maybe other stuff.
No, I mean, who knows what the final tab would be? That was one of the things I was hoping to get into if he dared to appear on rebuttal, but he did not, unfortunately. So, so that's a stark difference. The question is, did he sell out? He was hired. I believe he did the best job he could. He's just not very good at it, and he didn't have a lot to work with. And I think he gouged them.
Well, also, I'm telling you, I thought he thinks that he could have been the star here, And he's got a lot. I think he's got problems. Let me tell you, because remember, ARCA wanted to go public. Not ARCA. Aperture wanted to go public. Well, Welcher is a vice president of was it operations or whatever, but he's a vice president. They wanted to go public. They withdrew. They decided not to in 2022. My feeling is maybe they knew that Karen Reed was coming up. This would be like a great advertisement to go public.
Or maybe
now
they saw through Welcher.
Well, no, because here you got Shannon Burgess's issue. Do they both get fired? I mean, it's not past that he could get fired, that he could not be abused, because it was an embarrassment with those x-rays, and Brennan knew it.
Of course.
Yeah. I wanted to answer this question because I was surprised about this. Anika A. Linda, what about that prior bad acts instruction? Seems wrong to consider an argument between a couple, a prior bad act. What do you think? Michael Bryant, I thought it was absolutely wrong.
Of course, yeah. How many cases have we seen where prior bad acts being admitted when they don't match the pattern, signature, all of those issues you need to make them relevant and admissible have been ignored, and it comes in. Talk to Harvey Weinstein about that.
Right,
so no matter what you think about him, the fact is those things should never have happened. That's why he's got a new trial. And even now, those issues are raising their ugly head in the jury deliberations, where we're hearing the jurors are saying other jurors are bringing those things back into the case. Women who made complaints against Harvey Weinstein that were allowed in trial 1, which should not have been according to the appellate court. Now, even though not in trial 2, jurors are apparently considering them.
And that could have caused that guilty verdict on the count 1.
Yeah, and they're back today. They're still
they're also
deliberating
being
on the rape
threatened.
charge.
Also,
Yeah.
our two of them said they're being
The foreman
threatened.
said-
Another
foreman
juror
said,
the
I
judge
mean-
said, "Oh, too bad."
I'm being threatened. I don't feel safe. Get over it. You know.
Oh my God. Harley 62. Thank you so much. The donation for Michael's
Thank you.
trip.
Appreciate that.
Appreciate that.
I may
because-
get a large soda on the way now. I'm not going to get the little small one. I'm going large.
and also have something something good to eat. We'd love to get a former
Yeah, it's always
juror
good to
on the
eat.
show, by the way.
Driving. It's always great food to eat when you're driving.
Well, we
Lovely.
haven't been eating too. I've been eating.
I
We've
know.
got here some Twizzlers. My diet has been awful. I mean, I've held off
brutal.
like getting my annual physical because I don't want any blood tests because it's going to come back Twizzlers.
Yeah, it's going to come back the color. It's going to have ridges in it like Twizzlers.
And see, Curious Law Tuber gifted one
Thank you,
Justice for
Curious Law
TV
Tuber.
membership to us. Thank you so much. And another one, 2 of them. Thank you so very much, because people who get these, who can't afford to be members, they so appreciate it. So appreciate it.
And what a bonus, since I just so well worth it, because I just posted a video to our members only site there. So if you're a member, you can see that. I will tell you a couple of things. It is Domino and I stalking wild animals. That's all I can say at the moment, and teasing what happens tonight. I was out on the walk this morning. You will not believe what I found. This has nothing to do with the video because I found it after I shot
Dead
the video.
body? A dead body?
No, I found this. Do you see what this is?
A piece of tail light?
It's a piece of
Are you
tail
kidding
light.
me? You found a piece of
No.
tail light?
Yeah, just on the side of the road. It was, Michael Proctor was there, but I'm not sure that it's connected. Isn't that weird that I in the midst of all of this crazy, I find this piece of taillight. So I got to keep this I will keep this separate from my other taillight because I don't want to contaminate. I don't want to cross-contaminate these pieces.
I was suggesting.
But I thought that was weird.
I was suggesting, by the way, thank you, Candace. MP. You guys, thank you very much. We appreciate it. We work hard to try to do a good show for you. But I was going to suggest tomorrow that you bring the biting tail light up with you. Okay?
Yeah, I should, because where else am I
have
going to
in
use
your
it
car.
after this is
Yeah.
over? Yeah, I should.
Well, you never
throw that
know.
in
I
there.
mean, if this is a hung jury,
yeah.
it's going to be tried again. That's an
Right.
issue. And, this is a really scary time because did you hear the judge say, well, I'll let you be 10 minutes away as opposed to 5 minutes away. Right?
I mean, what is she? What is
But
the
judges
deal?
do that. They do that. They did that to us inspectors. They did that.
And when
you're
it plays
running
out,
in, you're
those
in a
5-10
hotel room.
minutes will mean nothing. They will
Nothing.
mean nothing in the big scheme of things. By the time
Right.
everybody assembles, and the attorneys will be the first ones there, and while the judge is messing around with this, and it's just a power trip. Let's talk a little bit about what happened this morning because there were some important procedural issues. It was left kind of vague last night as to whether the defense had actually rested because they were fighting over the Rentschler PowerPoint. Remember?
Yeah,
First of all,
what
I gotta-
happened with that? Because I missed
well,
it.
she's. What do you think? Take a wild guess.
She said no.
Of course. So here's what I think is outrageous about even having a discussion at this point. The parties argued over what part of that report, that PowerPoint, could be allowed in and not. And the judge went through slide by slide. This one's out, redact this, take this text off this, take this ultimate opinion off this. That was the time in which the Commonwealth should have said, we're objecting to the whole thing. We don't want it in. But they sandbagged the defense by saying, oh, you could use it as an exhibit with this witness.
Because once you show it, people have to understand.
Once you show it to
once
the jury,
it's an exhibit. It gets marked. It's not no longer unless you're. It's
I mean, people will
That's
know. Okay, here's my exhibit. I'm going to show it to the witness, lay a foundation. Then I'm going to offer it into evidence. Then it's going to be shown. But they let all of these slides, which was great that they did, because now it supports Rentschler's testimony, and the jury's not going to forget it. But if you allow that, then how can you make an argument without the court saying, well, no, you waived that because you allowed it to be seen for the jury? But no, the court said, oh, okay, well, let me listen to that. Let me think about it. And in the morning, I'll rule. So the morning she did, it's out.
It's ridiculous because the jury saw it all. Plus, they have, 144 slides of the idiot?
Yep, and that's in. And of course, her position is, well, that wasn't objected to.
They did object.
I'm sure they did. Also, Burgess's crap. All of that stuff.
They objected all the time. They filed motions about it. They objected all the time.
The only saving grace that makes it slightly, I always look at things in terms of appeal, makes it slightly less reversible error, is that Wolf's entire report is coming in. We know it's based on all of those same tests. All the same videos are going to be there. And you'll have Rentschler's testimony that relates to those. So I don't know, if I were to look at the two reports, I don't know what the very specific differences are. But those differences are not in evidence.
I don't think, because it was a PowerPoint. It was a slide to show you. And that's the difference.
They even talked about, remember this? They talked about the judge saying, well, can't you have it on a thumb drive? Because that'll be easier when the jury has it in the jury. Right. Remember all of that?
Right. That's what she said. She's so unfair. Okay. She's so unfair. And, if you're Karen Reed and you hear, okay, you could be 10 minutes away, but at some point, we're going to have to talk about security, if you know what I mean.
Yeah, ooh,
so what is she saying?
We don't want that.
At some point, we're going to talk about, well, she could get convicted, so we're going to have to talk about security, okay? Come on. All right. Come on,
what was it? I was trying to think of, there's another procedural issue today. Obviously, Alessi wanted to make his follow-up request for another instruction.
Didn't she hammer Lesby? Didn't she give him a dig of some sort?
I don't know, other than pretty much ignoring what he had to say. I don't remember the dig. If anybody remembers that, remind us. But yeah, he wanted to make the argument, and on the record, that they need more in terms of an instruction regarding the holes cut in the sweatshirt. He did point out, and I forgot how this played out. When he said it, I remembered. So Brennan shows the sweatshirt to Dr. Rentschler. Isn't it? Did you consider these holes in the back about it? And then Rentschler starts to say, well, they were cut. And then Brennan interrupts him and basically goes on to the next point of his cross-examination. So even Brennan is advised by the witness, just briefly, well, these were cut.
Right.
But Brennan doesn't let him either elaborate or agree with him and say, oh, you're right, my mistake, or something. He just lets it go. So obviously, I don't think she's going to give a supplemental instruction on that.
No, she doesn't have any grave concerns about that kind of. And I'm going to say it, misconduct. All right, misconduct at that point.
Yeah,
because you have a duty.
Can't claim mistake. Mistake is innocent. Right. This is fraud.
Yeah.
So
this is misconduct. A sweet New York. Okay, let me see. Maybe I have to. Sweet New Yorker.
Sweet New Yorker Mar.
Okay, I'm sorry. I'm still getting used to having really.
Oh, so they did finally get a mistrial on the
third count. On the third count.
So I will send congratulations to.
Well, I don't know if you congratulate. The client got convicted on the top charge. I'm not sure how much congratulations.
I don't know. The top charge was a sexual assault, right? I mean, the one that was convicted isn't. Well, rape is the harsher penalty than the sexual assault.
Yeah, well, yeah.
So they got off on the top charge, I would think.
Yeah, so anyhow,
anyway, I'm
so
going to
we'll
send
see
a
if
note
we-
just to see if Imran's going to be able to make it or
Right.
not.
And maybe Arthur will tag along, Arthur Idella.
Yep.
I don't know how Arthur was making appearances all over TV this time, looking dapper and wonderful and terrific, and then going in and reading that really hard trial, hard. Just amazing man, Arthur Idella. Really terrific attorneys. Okay. So yeah, we'd like to find out, because I think that whole idea, I think when two jurors come out and say that you have to have a hearing, you then have to have a hearing. The judge, again, no hearing.
Course.
When
Of
two jurors
course.
come out and say we're being threatened, you have to have a hearing. Now, that's
They should
stupid.
be.
He's upset.
I know, very upset about the verdict. So they're obviously they have an amazing chapter in their appeal for the one conviction, and that is juror misconduct.
Yeah.
You know?
Yeah,
So-
I mean, but why not a hearing? This judge certainly had, even this judge had sort of a hearing. She called the juror up, Sidebahhh. That's juror number 3 we heard last night about the drinking. And she said when she drove home, she was so mad. She was
I'm
so
sure.
mad.
Yeah.
She felt that she had been, well, I'm not even going to tell you. Please, everyone, go listen to Aiden's interview. And I know Aiden's in trial right now for the 3rd day, and Oasis Cat has been telling us what's been happening.
You're supposed to be done today with that.
Okay,
Yeah.
hold on a second. Oasis Cat, Turtle Boy, per Jess Machado, who is in court, and she's the one that we ranted about that should have a seat, and she's been in a lot of seats now. It's great. Bradel is starting off by asking about the day in question. McCabe says that he never had met Lindsay Gaetano before that day. So I'm not sure where we are in that, but there's such, I don't want to curse. I don't want to get spicy, but it's such garbage charges. All right. These charges. I mean, but they're there. And it's, the danger is, here it is.
At least it's not a jury.
Yeah. This is not a jury, but the danger still is, we know these judges don't like Aiden. Jess McCabe is saying he didn't know who Lindsay was when he was in the courthouse, but Bradel just went back to that and asked if when he saw her, was she holding a piece of paper who says who McCabe was. Excuse me, you can't come in, I'm on the air.
The electricians are coming down, look for the hot tub.
Oh, that's even better, but I'm on the air. So now everybody knows the electricians are coming down to look for the hot tub. Hi, everyone. Oh, that's great.
Congratulations.
Well, they can't come down this way. They have to come down the other way, okay? They cannot come, excuse me while I get off for a second.
Okay, why don't
Why don't I just stop my cam and mute?
Go
Hi, all. You know I have electricians here now. And a husband even.
Yeah. I had Lisa popped in yesterday to say she was going to the store, see if I needed anything. So, oh, there she goes. Anyway, so that was important. I want to get that procedural stuff out of the way because people were wondering what the hell happened, because there wasn't a more formal, the defense rests, Your Honor. It was more, hey, are we going to get this report in? Oh, we're done. Oh, there are no rebuttal witnesses. So I was just talking about how kind of loose and sloppy, speaking about electricians, how loose and sloppy the ending of the day was yesterday. People couldn't quite figure out,
what
happened? Are we done with the defense? Is everything in? And I was going on about how important it was to move all the evidence in before you rest, so you don't have to move to reopen to put something in, right? And so it was a bit of a mess, and it technically really wasn't closed until this morning, because they were still waiting for the ruling on whether or not Dr. Rentschler's PowerPoint was going to come in or not. I'm sure they were thinking it's not. And by the way, it's not. And so now that's all done. Now the official resting has taken place. Dominic. And now we're moving on. So jury charge conference, much shorter than I expected. One thing I did not hear, which means I'm guessing it's no longer an issue, that the Commonwealth got spanked for even suggesting the intimidating the witnesses charge. They wanted some sort of no charge, lack of charge. They wanted a jury instruction suggesting that the jury should be informed that if they were to find that Karen Reed intimidated witnesses, it would somehow impact the other charges. Well, there's not a witness intimidation charge on the table here, unless it's going to be some sort of weird, twisted, lesser included. I can't wait to see the verdict slip to see how convoluted it is this time around. Sad to see they didn't take an opportunity to fix what was a key problem last time, which was, can we come to a unanimous decision on any or all of the charges, or do we have to come to a unanimous decision on all or none. You know, I'm still ranting about that because she had the perfect opportunity to
I
fix
can hear
that.
your rant as
And it's
as the whole
not.
house is in
It's
turmoil.
it sounds like.
Here.
Are you in another room now, or just turned sideways?
I moved to I
Oh.
actually moved to my office, the TV studio in my office where we were having the RFI. When the electricians came, I was going to have them check the RFI of the TV studio, but I didn't know the electricians were going to be here. Actually, he's a
Like,
great electrician.
hey,
Every week.
just
one
coming
of my,
through.
I know my husband's coming down because he's here, and he says he's on a Zoom. I said, so you can't come down. I'm in the middle of streaming. He said, well, I'm in the middle of a Zoom conference.
Yeah, that would have been a cameo.
Yeah, did you all see that? Did you all
cameo.
see the cameo of my husband coming down? Or did I get
We
the,
heard, but you threw the legal pad up there. Fastest legal pad in the East. Yeah. Okay,
Yeah,
so
you can't make this up. I'm sorry, everybody. You know, we may be infectious.
they like this stuff.
I know they do. I know they do.
So I really do have to get out the door and get this stuff underway, or I won't get back and prepared for our 6 o'clock. So anything we
Right.
haven't touched on?
No, there's a lot of questions here, and you know what I'm going to do is I'm going to go through the questions because I see some really good ones about whether the 3 jurors getting removed and whether I'm concerned about whether or not there's going to be a fix in this trial. I can tell you some stories about palming the numbers. Okay.
And we haven't talked about when that's going to, practically speaking, when is that going to happen? And I think it's after the instructions. Is that right?
That's right. It's after the instructions.
So you have these alts that are, getting bored by the instructions that they think they may have to deal with, and then finding out they don't have to deal with them.
Yeah.
It's I guarantee you there are going to be 6 very unhappy people.
So because they all stayed when we were worried about losing them. In any event, so we do have a 6 o'clock show. We're going to try to get Imran on to talk at the end of the show about what happened in the Weinstein trial. But what are we doing? We're actually going to go rewinding and taking a look back at the openings, aren't we, today?
That's what I hope to do. If I get out of here and get back in time, that is the plan.
Okay.
So I'm
why
going to
don't
leave.
You get out of here? You leave, and I'll
you.
close up the show. Okay.
All right.
All right, let me see if I can answer a few of your questions here. Just a funny morning, as you know. So this is what happens when you're live streaming in your own TV studio in an upstate cabin where there is no room. Okay, there's 1,100 square feet. Okay, this is the one I wanted to talk about. Anika A. Linda, are you concerned at all that last time 3 Kenney favorable jurors didn't make the final 12? Is the jury fixed? Will it happen again? That does concern me, okay, in one way. In another way, it suggests that there's some really strong evidence for a not guilty here, that 3 felt not guilty. It also gives you an indication of who the ideal juror was for Karen Read in the last trial. And it appears to have been women who apparently are still friends. She's still friends with Victoria, who was on the defense team for a while. So I assume that when the jury was being picked, one of the things you had that sociology aspect that jury consultants look for right from the first trial, that they are looking for women, because apparently, again, I said it's important. I would go back and listen to Aiden's interview with her last night. It was long, but it was very detailed, and it was very good and very interesting. And for any of us who've ever tried cases, that they all felt very strongly that Karen Read was being set up, all right, very strongly in the first trial. And then the second trial is interesting because she said with all that fluff removed, she wasn't sure what was happening on May 29th when she first, and they were very open about the text, but now there's no doubt in her mind, again, that Karen Read has been set up, okay? So I say that only because I don't know whether fixes happen. We were all concerned about how some kind of conversation in a Knights of Columbus or some type of hall 6 weeks ago got to the judge, and she foisted it upon the juror who didn't even have time to think. I mean, I can't remember what I've done 6 weeks ago, who I talked to. And if I were told I couldn't talk to somebody about somebody and somebody starts talking, I just may not say anything, right? You don't leave your conversation, just yeah, and we've all been there. We've all been there at situations at a dinner that we've gone out to, or even with our family, or just sitting around, talking to people where they're bringing up something you don't have any part talking about, or you don't agree with, but you don't respond, right? And so I think that she felt that the whole thing was unfair to her, and listening to her, it sounds like it was. Now, I've been in a case where there was a juror that defense counsel, prosecutor and myself and the judge all agreed shouldn't be there. And I forget the reason why, what happened. So we all agreed that jurors shouldn't be there. And sure enough, when the court officer picked the first number, and it was agreed that Judah couldn't be there, what's the first number that comes out? The juror that we all agreed should not have been on that jury. Okay, with that, you don't want to make a big deal. You don't want to tell a juror and all. And so there's a way for the officer, and I was in New Jersey. They show you the number. Here it is. Boom, boom, boom. Yeah, look at that. So obviously that number was palmed, right? So can things be palmed by court officers? Yes, they can. Are they supposed to be palmed? No, unless there's an agreement of counsel and the judge, okay? Because sometimes you don't want to hurt feelings or something. But there was also in New Jersey, where I'm from, I have all these stories of friends. There's a county called Essex County, which for years was just totally Democratic county. And for decades, it was very important which column, though, of the ballot in New Jersey you were on, because there were a lot of different people running at different times. The Democrats, for like 25 years, always got column 1 because it was the same clerk of the county, the voting clerk, whatever they called him at that time. He picked out of the wheel who was going to be first. And my gosh, every single time it was almost a Democrat. All right. Now that's not either good or bad or indifferent depending on who you vote for, but it goes to show you my experience is, can it be done? It can be done. Okay. So just take that for what it's worth. I'm not suggesting that here. Okay. All right. Lesson in Texas. Thank you very much, Linda. You're 3/4 way to Texas here. Yeah, I am. I know. Isn't this? I actually had Gladys do my hair last night because I was going to a function after I finished with you, and then I knew I was going to be. So I said, make sure you tease it high. And I'm like, oh, this is when I looked at it last night. I said, I do have Texas. Either that, or I thought maybe I have Bridget McCrone hair. Okay, it's going to have to come down. I mean, you will see it come down. I don't know by tonight, but certainly by tomorrow when we're on all day, this hair is going to come down because you're right. Yeah, you can get a ride. Yeah, but probably Texas. I can catch up to what was it? It was Welcher who said that the car could be shot up in outer space. I think my hair is going after that car. So, but anyhow, it's good we can all smile at ourselves and laugh at ourselves, including my husband's in the middle of a very important Zoom, apparently, with his state agency. He's got the electricians, and you come down, and Tubi's barking, and this is all happening, and here we are all together, So, I know you're back here because we try to answer your questions. We try to do it sometimes with a little bit of humor because it's very, sometimes it's very hard to have everything so awful, around me, because this is an awful case. It involves a death. Okay, blessed in Texas, they say, higher the hair, the closer to God. Okay, I love it. And thank you, blessed in Texas. You're just so generous to us all the time. This is what I was talking about. Amy loves soccer. That juror number 3 told Turtle Boy she spoke with the defense about her experience. Yes, and I'm sure any jurors who wanted to speak to the defense would have. She almost, interestingly enough, called the defense around May 29th on this trial. She thought she was going to call Karen, she said. So maybe she's spoken to her to tell her, hey, you got to do something more here. Okay. So I thought that was really interesting. But according to her, they did a lot more. Okay. They did a lot more. So I agree. I mean, I just think that's where you had to go with this case. I think the whole idea, the jurors, the first case were all the ones that hung were like, we don't believe this 25-person conspiracy, but you can believe that something went on here. You can believe that evidence somehow was planted for whatever reason, whether it's the cover up of a cop, the cover up of a dog. Where's Chloe? You heard the prosecution this morning loudly say, well, there's no evidence that a dog was even there. Well, yes, there was. There was evidence that a dog was there because they got it into Yuri Buchanan that a dog that allegedly had come from the house that had belonged to the Alberts ended up apparently in Vermont with a different name, some different name and all. So I guess the prosecution is going to say, well, even the defense said the dog may not be the same one that was in the Alberts house, but the specter of something not right in River City or something rotten in Denmark is there. Oasis Cat, per Jess Machado, Paul's attorney says he understood he must testify, but to give over phone records, he disagrees. Judge is asking Bradel what he wants this for. Bradel says motive. So this is turning out to be quite a little trial that Aiden is in over there. Okay, so the trial yesterday was streaming only in audio. Oasis Cat, do you know if it's streaming, if there's any streaming of it today? And let me just check, because yesterday what happened, there was no formal streaming, but Turtle Boy himself was streaming it, and they actually, I believe, there was some camera crew in there that was recording it, but it wasn't a formal stream. So let me just go to his website page. You probably all have done this because, as you know, I was traveling up here this morning. Let's see. I'm looking at Aiden's. I don't see looking at his ex Twitter account this morning that there is a stream for it. There was a stream link yesterday, but Jess Machado is reporting on it, and he does have a breakout of the juror interview on his page. Okay, so that's where we are. But I don't see any stream that Aiden posted today. If you do see it, Oasis Cat put it up. But yesterday he posted a stream that he was streaming it, I think from his phone or something like that. But it was only audio because he was on Will the Galera's show driving home, right? Doing an interview as he's driving home. Actually, he wasn't driving home. He said he had to drive to Worcester to go buy a suit because he didn't expect the trial to go for a third day. All right. So Will and Mike Crawford are streaming it, I believe. Okay, Oasis. Will and Mike Crawford are streaming it, I believe. So if you look for them, you should be able to find it. We are not going to be streaming it. We will be following it, but we will not be streaming it here on this channel. So if you have any other really biting questions that you want us to answer tonight, send them to us at justiceservedtv@gmail.com, and we will answer them. And we're going to be back on the show, obviously, at 6 p.m. tonight. We're going to run through some of the openings. I know you're not going to want to see Hank Brennan's too much, but we have to do a little bit because where he was opening should tell us how he is closing. Just like Alan Jackson said, wait for us, okay? Wait for us. And when we did, especially after that brutal day where the judge trying to eviscerate their case, cut them off at the kneecaps, we waited for them. And Alan Jackson, such a great lawyer, I have to say, that he got in a lot of the information that the judge didn't allow in, but he got it in another way, and now he can argue it by inference. And it takes a great lawyer to do that. Otherwise, Karen Reed would have been royally messed up in terms of her evidence that she was presenting. And by the way, she doesn't have to prove any of it. She just has to raise the specter that the prosecution hasn't proven their case beyond a reasonable doubt. So with that, I will say almost afternoon. Go have a great afternoon. 2 more minutes. I don't want to be Dr. Dr. La Posada with Hank Brennan. Have a great afternoon. We'll be preparing for the show, and we will see you at 6 o'clock tonight. But before you go, please hit like. If you're coming from X, please hit subscribe. Come over to our YouTube channel and subscribe to us. It really helps us get into that algorithm feed where we're pushed out for all of you. And then you can hit share and the notify bell for all, and you will be notified when we're on the air, even if you didn't follow us for that day. I'll see you tonight. I'm Linda Kenney Baden for Michael Bryant. Try to do the right thing.